My name is Stacey Cohen. I'm an attorney. I've been an attorney for 22 years, and I volunteered for this speaking engagement after representing, she was 82 years old, a widow farmer, and seeing a real need on certain levels, be it, there's many people here, very sophisticated, some who are not, and really, unfortunately, what happened with her, everything that I'm sure Bob spoke to this morning, I wasn't here, but I've heard his seminar, that could befall a family really happened in her situation. A farm, a rather large farm, over 1,800 acres, had been started in 1945 by two patriarchs, I'll call them, the two fathers. And it was a partnership structure with the wives of each of the husbands having survivorship interest in the partnership. Well, one side had lineage, they had kids, and working on the farm they acquired more property, so there's a lot of homesteads. The one side, my client, no children. And really, after the husband died, there was disbelief and shock, because none of the kids, no one really understood what would happen, that she would acquire everything. She had no interest in farming. Things like selling off machinery that was titled in her husband's name didn't go over very well. Also, issues of she was still leasing out property but paying all the taxes for all of the farm property. The other side wasn't necessarily contributing any of the income coming in. There was problems with one side not wanting to do any further work on her side of the property. It all boiled down to, towards the end, they got in trouble with the state for not having addressed dam safety issues. They had all sorts of problems. The one side needed to raise capital and wanted to go into farm preservation, couldn't. And through the logjam that occurred for well over 5-6 years, I was brought in to do a partition action. And the amount of money that was spent, the agony and the emotional rift that occurred, it was tremendous. And you ended up with an 80-year-old woman ostracized from her family in Salem County, which, you know, that should be her network at this stage in her life. And I really thought there was a lot that could have been done on the planning side. And actually, the attorney who I worked with, who brought me in, had pleaded with the family to do estate planning and to redo some of the structures before this occurred. And it did, and it was very sad. I do not do the drafting of the wills and the documents. I generally get involved as part of a team, and it's more on the implementation of the plans, because there's generally a lot of real estate transactions that have to occur, a lot of valuation issues, sometimes subdivisions, any permits and approvals. But I also do litigation, and often my services are required when something goes amiss in the process, and there is a probate matter that's filed to challenge a will or challenge any of the distributions. What I had chosen to speak about was really, in this complex and sophisticated area, one of the most important decisions you make that I think where you'll be best served is choosing your attorney and making the best choice. And you might actually meet with a couple, but you want to look at someone who has the level of sophistication, background, credentials, experience, and someone you feel comfortable with that can guide you through this process, especially if you have an operational entity, a commercial business, you have multi-generations, there's a lot of emotional issues. Really looking at choosing the right attorney, I can't go over how critical that is in the area of estate planning. It's generally recognized, and the American Bar Association has done reviews on their committees on malpractice, that it's generally in the top 3, short of divorce and maybe personal injury, where everyone doesn't like their attorneys. But it just has a lot of areas where there's tax issues, there's ramifications that need to be thought out well in advance. There is the idea of also, you want to avoid litigation. Maybe not malpractice, but the better drafted documents and the better understanding of the party avoids the problem down the road. And again, that just avoids time, money, and more emotional strife between family members. And also, that may be the make or break decision that helps an entity, a farm or other operation continue, where you don't have to sell off assets. There's succession planning. So in choosing the attorney, where are you going to look? Probably your first line is your friends, your family, and maybe your business associates, but I also say go to your existing accountant, go to your financial planner. You may go to your existing attorney. I give referrals all the time for estate planning. I just had a couple come to me the other day, and I felt it was a second marriage for both. There were two sides of children. This is not an area that a general practitioner, especially where there's substantial assets involved, should be handling. You're not well served. And it's surprising how once you have some life insurance policies thrown in, the net worth and the assets can accumulate quite rapidly, independent of any realty interests. The county and state bar association all have sections that are comprised of practitioners that specialize in this area. Now, they say they specialize in it. There's no real criteria for entry. There's no testing. There's no educational. But it's those that are interested in the area and generally do practice. So if you want to have a starting point, there's several organizations, and I'll speak a little bit about those, where entree into the organization, I think, is a bona fide credential for at least giving someone credibility into this area of practice. If you understand the criteria for entry, you see the value. The National Association of Elder Law Attorneys and also the National Association of Estate Planners and Counsels has different designation. It's SELA for the NALA and it's the EPLS for the other entity. And these organizations, there's a criteria where you're in practice for certain number of years with a certain concentration of your practice truly devoted to different areas of estate planning and elder law, and that has to be proved. There's submissions to the organization, there's review committees, there's also peer review. You have to have recommendations from a number of other practitioners for your entree and your achievement of this designation. And then there's also testing. Several days of testing. So again, if you're looking for someone who is a true practitioner in this area, looking at all those nice little designations after their name is certainly something that can give you a little bit more comfort and assurance. There's two educational designations that I certainly think are viable and valuable. You've gone through an accredited law school program. An LLM is a master's in taxation, and that's generally over 20 hours. There's some other programs where they're certified estates attorneys. It's generally half of the LLM program. Some states have it. I know like Temple University has it, so there's many in South Jersey that have that designation. Again, you're going beyond your JD requirements. You're going to school for further education. Now, a number of the attorneys in the estate arena, generally CPAs, they have other designation, they're CLUs, they have other things that will be designated, and an attorney is permitted to advertise other designations. I would think many of the LLMs, the percentage that are CPAs is pretty high. But be conscientious. You're going to look at credentials, you're going to look for referrals, but do your own due diligence. This is also an area, especially in the elder law arena, where people are taken and there's frauds that occur all the time. I just represented a woman, and we had we obtained a judgment for over $3.5 million against the attorney for malpractice. He had been a founding CEO of a bank, had sought political position, had been on a radio show as a host for financial matters, seemingly great credentials, renowned in the community, and he did He did actually do a lot of things for a number of clients. There's a number of claims against him through the Client Protection Fund, which the State Bar Association has to assist clients whose attorneys steal from him. The Attorney General has indicted, and he's pled guilty to some other counts. We've gotten civil recoveries, but still the amount of trouble that they can befall on a client who has perhaps turned over certain powers to an attorney, it's really worth just making sure you can do as much due diligence as possible. You can always look to see if there's ever been any ethical claims against an attorney, and that might just be something you want to check out. When you
How would you go about
Office of Attorney Ethics. Okay. And again, that's because once they're filed, things are a matter of public record. When you're preparing for your meeting with an attorney, they may send you a questionnaire, and I think, Bob, did you hand out one before, which has some general informational requirements. They're looking to know your assets, your liabilities, as well as a lot of background and personal information. And I've seen some of the questionnaires that attorneys do send out. You'd be surprised.
I handed out a meeting checklist of meeting with professionals checklist.
But some of them will have more proprietary questions, and they want to know the ages of your children, anyone who you might have an obligation or a desire to take care of. But they'll delve even deeper, and most of the information, it seems very personal. Well, they need to get personal. They need to know how they can best help you, and that's going to be by what are your needs and goals, and setting that up. So you're thinking about that along the way. They're going to ask you, and there's a lot of documents they may ask you to physically bring, and that's because it's much easier for, once you bring the life insurance, or you probably don't have the designation of beneficiary form anymore, but they have a record of it. They're looking for any deeds to see how things are titled. They're looking for obvious things like bank accounts, stocks, CDs. They want to know if you have any more unusual type assets. Might be a boat, might be an antique item, it might be something of an inordinate amount of value that you need to understand what's going to happen after that item is valued, because for tax purposes, as well as if there's any disbursement or any issues with beneficiaries where the value comes into play. If that is the main value of an estate and you have multiple beneficiaries, well, either someone's going to have to pay out for it or it's going to have to be sold. And I did represent a client who his estate included a lot of museum quality clocks and barometers, and they were all sold at auction. So you have to understand what is the nature of the assets. Life insurance policies, and many things which are perhaps non-probate, and I know Bob talked about the distinction, what goes into your estate and what passes outside of the estate. They want to know holistically, what do you have, because there's ways of perhaps between beneficiaries or heirs making it more equalized or fair, in the sense that someone could get life insurance proceeds and someone may get an interest in a farm. I'm giving that as the example. They're going to look for your safety deposit box if you have one. And that's a typical place where then they would also instruct you if you wanted to place your will in the box, letters of instructions, any other, your life insurance policies. And they'll also look to see what business documents you might have. Are you a partner in any type of entity? Do you have an LLC? Any type of corporate interest, because that, again, that could be part of the estate, and it could be something for purposes of understanding valuation. When they ask you the questions about other individuals, and they may ask you about special needs, if anyone in the family, a spouse or a child, anyone has any potential for any debilitating disease. If Alzheimer's is running in the family, no one's been diagnosed yet. They may want to know things about, the spending habits, which is someone have a gambling problem, any type of a problem where, hey, maybe it's not a great idea to leave a substantial amount of money directly to this person. during this time while they're asking you to get information you're preparing, you really have to start focusing on what are your goals. And it really is a provocative process. I think you have to look at what's most important to you. And you're going to have your financial needs, and you know, the accountants that are here understand that it's going to drive a lot of the tax issues and implications. But you're also going to look at, you know, what is your life expectancy and where are you looking to stay. Some of the more lifestyle decisions that come into play, and I think any attorney will ask those questions. So you need to start thinking about it, because you don't want to wait until you're meeting with the attorney and not have really thought this through. And it's a fluid process. You may think about this after you meet them as well and change your mind. And that's something that often happens, because I think once you meet with the attorney should tell you both the pros and the cons of what you're thinking, because truthfully, nothing's perfect, because no one can predict the future, and things change. You know, real estate values drop. You know, all sorts of things could happen. If it is beneficial to transfer outside of a state, they're going to try to talk to you about gifting. So you might have that thought in your mind now before you're going there. Or Medicaid planning is a big issue for many individuals, and that's something, again, it's part of the thought process before you're going to the attorney. Should be thinking about it, just to generally understand where you want to go. When you meet with your attorney, he's going to go over with you those goals that you've been thinking about and what it is you may want to accomplish and how best to try to accomplish that. I would say he or she should also tell you the pitfalls of what your thoughts process is and what you're thinking, and just so that you know. You know, again, it could be the timing of a distribution where you give an age or a triggering event. Well, you know, it could be marriage of a son or a daughter, and guess what? They get married at 18 and they're divorced by 20, but there's already been a distribution. So those are the type of things they should be educating you. They will ask you, and this could also be done at this time, or they'll tell you to think about it, because it really is just the identification of individuals. But there's certain individuals they're called functionaries of the estate, and usually they'll ask you if you're setting up, you know, a trustee who will have powers that are enumerated under the trust, but they do get to control your assets, and that's one of the areas where you want to make sure you make the right decision. As far as an executor, or if the court appoints, and it would be an administrator of the will, that functions a little more administrative. The role of the executor is to marshal the assets, gather them up, pay out bills, find out the debts, and then make all the requisite tax filings that need to be done, and then they distribute finally to the beneficiaries. So that's a little less discretionary. Certainly in a trust, you have different powers, and they should be written clearly in the trust document, but there's certainly no one watching over. In a will situation where it's probated, there's always can be an accounting requested of an executor. So there's other safeguards, but really when the attorney talks to you about identifying individuals, maybe for the executor/executrix, you want someone that's proximate in distance. You don't want someone who it's going to be a real burden. You want someone who can handle, even with the assistance of maybe a CPA or an attorney, there's still a lot of paperwork involved. Someone who is best equipped to handle that just by their very nature, personality. You always want to have alternates. Someone could not qualify or not accept. Someone could just not be around when the time comes, you know. So you always want to look at having substitutes or alternatives.
Stacey, could you designate, someone asked me at lunchtime, you know, the difference between a power of attorney and the executor. I kind of mentioned that executor, I think, is only takes effect after will. Is that true? The power of attorney, generally, it stops when you die. There's no longer a power.
The executor, and this goes into the probate process, 10 days after death, you would go to the surrogates in your county or the county of residence of the deceased person with the death certificate, And you have to qualify. Qualifying is essentially certifying that you'll fulfill the duties, and they're statutory. And you would qualify and you would get letters testamentary issued and a certificate. And the certificate for the executors usually is what enables them to then, it's documentation that they can then show to banks and otherwise to act in that capacity. A power of attorney is when someone is alive and just ceding the control voluntarily to another individual. There is something with a power of attorney, though, when you are in probate, you do execute as an executor a power of attorney to the surrogate's office to accept service of claims if some individual is making a claim against the estate. So that's the only other power of attorney there is. Aside, go ahead.
Because actually, my parents are both elderly, but they're both still alive. My brother and I are executors and have power of attorney, and I believe I'm a trustee also with my mother on my father's estate. So I had asked because I don't understand the difference between all. I mean, you're explaining
the power of attorney you have. It's while they're alive, whomever you have the power of attorney over, and it's premised on then the powers that have been provided to you under the document. And that's separate from what will be triggered once an estate is probated, which is an executor is to manage the estate's affairs. For example, as a power of attorney now for your mother, you might have the ability to write checks on her account. When you're an executor, generally you're going to open up a separate bank account for the estate. And that's, certainly you can withdraw certain sums of money from the existing accounts, but you're going to set up a separate account and act under a different capacity at that point if you're functioning to pay the estate's expenses, pay out some professionals, make tax payments, any filings. And then as a trustee, you're operating under a separate document. It's a trust document. And it may be a trust that comes into play and is funded at the death, but it's a totally different power, and the powers are set forth in the document itself. So you can serve in all those capacities.
I have one question, if you don't mind. Just as far as the qualifications of the executor, what does that look like as far as from the surrogate's office?
I believe it's a certification that you're going to fulfill the duties. I mean, I can't say what every surrogate's. There's a different surrogate's office for every county. So, if there is no executor or executrix, the court can appoint one. And also, just so that you know, if there's a reason you believe someone should not serve, and this goes into more probate litigation, you could seek to oust someone from that capacity. And really, that's another application. And at that point, there could be a co-executor appointed or an administrator from the court. When you're discussing the probate process, and I think we just went through the letters of administration, and if an estate is under a certain threshold value, and in New Jersey now it's $10,000, you can file a certification, you can avoid probate. Probate is not necessarily a quick process, and depending on how things are moving along, it can take quite a bit of time, and there's certainly some things to watch out for. If you file your return, your inheritance tax return before, there's an 8-month for your inheritance tax return, and you avoid the interest. But things can proceed at a snail's pace. I wouldn't think someone dies, you're going to get your distribution the following day, or even within the year, and that poses its own set of problems. It's why in succession planning things need to be addressed with the attorney for planning if you have an ongoing business entity, or if there's financial needs that need to be met on an ongoing basis for some of those who might be incapacitated and are financially dependent. So those are some of the things that they'll help you through the process. usually it's required that heirs, beneficiaries get notification that, hey, the will is being probated, and that has to be done within 60 days, and they're entitled to a copy of the will. And again, this is just notice so that if they have a problem, again, they're being provided the requisite information to present any challenge that they might have. And a will challenge has to be filed within 4 months of the will being administered for probate. Generally, will contests go down a couple different lines. One is the challenge to the validity or the sufficiency of the will itself, execution requirements, whether it is the true and last will, whether or not there's a codicil that came later that might change a provision. Then there's challenges to, I'll say, the directions of the will. What were the beneficiary designations and the allocations? And generally those come under people claiming that one person was getting a disproportionate share of the estate as a matter of having exerted undue duress or coercion. A lot of times that's the caretaker, someone who was close at time or may have, had more of an influence than would have been appropriate at the time based on the condition of the decedent, the person who died. Another area that is pretty prevalent in terms of probate litigation at this time is looking at how the estate is being administered by the executor or the executrix. Individuals may think that they are misusing the estate assets or not undertaking their obligations, failing to act. And that type of litigation is filed, and generally they're looking for an accounting, or they're looking to oust or replace the functionary. There's also a lot of litigation surrounding pre-death transfers, and again, this may be by someone who at the time was operating under a power of attorney, or gifts that perhaps are seemingly large at the time. So one thing to know is if a challenge is a viable and bona fide challenge, you might not be successful. Generally, the costs of the litigation are borne by the estate, so in any way to avoid estate litigation, you're going to keep the estate intact. You're dissipating assets to pay attorneys and to pay professional fees, and that's something to keep in mind, and that's one of the reasons to keep the drafting and the actual execution of the documents, to pay as much attention with clarity and understanding of the testator's intent. We were talking about, what happens afterwards, and, it's not unusual that people don't let anyone know about their will. And it really isn't a good thing, because hopefully you would have talked to someone about serving as your executor. It's not a shock. Or, just what your requests are. There's a lot of people that, will come to me and say, did you ever write a will? Do you know where their will is? And that delays the process. It adds uncertainty. Or people don't want to act as an administrator or an executor, and having had that understanding beforehand, probably they would have picked someone else. There's also the idea that, if you don't know where the will is, and it should be with some other important documents that we'll talk about, no one knows that this has been done. Everyone's concerned. And it's a bad time for family members anyhow. You're just adding to the mix. Everyone should have a will. It's not, it shouldn't be something secret. It could be in a safety deposit box or with the attorney. And by the way, whatever you say to your attorney is privileged, confidential. It's not open to anyone else. And one of the things when people go to an attorney, sometimes there's multiple people. An attorney will generally have a letter of engagement and identify who is the client. And the client may be just the one individual. It may be it can be spouses, but generally they're not looking at representing multiple people. That doesn't mean that multiple people don't show up and add some input, but the attorney is serving the client, and anything that is done with others present, they're waiving that level of confidentiality, and that's really important for later on if there's a problem down the road and there's some litigation. But it would be perhaps an inherent conflict if they were the attorney were representing 2 generations, and what may be good for the older generation in terms of planning, Medicaid planning, or other aspects may not be as beneficial for the younger generation in terms of their tax issues. But again, they have to describe what is going to happen. Everyone being there is helpful, but really the attorney is only serving their client. Once you have everything in place, one of the things that happens is people don't redo their wills. And it shocks me every time I see a will that's 15, 20 years old and things have radically changed. Generally, people change their wills at life cycle events, marriage, birth, divorce, but there's other times when it really makes sense to look at your will. You look at your will, your financial situations have changed. There's a change in you having come into money, certainly having different medical needs, forecasting different ideas, or other individuals that all of a sudden you're taking on care and responsibility for. So looking at it is not necessarily, it shouldn't be difficult. It's really looking at what your needs are at the time, and they're always changing. It's fluid. There might be a change in your functionaries. Someone moves out of state. It's not really all that convenient for them to be the executor necessarily if you have a lot of realty involved and they're not going to be around. Your attorney should be, as well as perhaps your other financial professionals, letting you know about changes in rules and regulations. And that would be also a trigger point for redoing your estate planning. As the laws change, and we've heard over the course of the last 2 days, different people, all of a sudden their life insurance is no longer needed to pay estate taxes as they raise the limits. So maybe that can go towards another, satisfying another element of their planning. But again, it's just a change in the taxation structure and anything else which could be important for understanding your needs and helping you address your goals. When you look at the difference in planning from, I'll say 10 years ago, now they're having much more of an emphasis on LLCs, and I see that from the transfer standpoint, but it just changes as the vehicles and the different types of opportunities arise, and those are still changing, different types of trusts and what the pulse is in the financial arena. So, anyone have any questions? Oh, let me just mention 2 documents that if you don't have them, everyone should have them, and you should have a power of attorney and an advance medical directive. An advance medical directive enables you to designate a proxy to make medical decisions. It should be given to and it's made part of your health records, and it should also be given and discussed with the person that you designate. And again, who you designate, it's a real personal decision, but the way I like to look at it is designate someone who you think is going to handle things under stress, who's going to be there physically, and who can really live with honoring your request. It won't eat them up. And that may not be the person, you may want to shield the person that you don't think can handle that role. The advanced medical directives will designate what types of care you want under specific circumstances. And it's not just a do not resuscitate, but it's also, do you want hydration? Do you want nourishment? Anything that you want. And, this is a time also you may have some questions, and your medical provider, and they generally go over this with you to make sure you understand what it means to have some, treatment withheld. And I'll bring back my situation with my mother, where she was very clear she did not want to be on a respirator. And they went up to my father, who was her proxy, and said, we're going to make it easier for her to breathe. Now, they didn't say the magic word, and he didn't really understand. And we had to, say, Dad, this is not what she wants. So, there is a value in having the talk. It's not as scary as you think. In terms of the power of attorney, and you had a question before, there's some stringent execution requirements because you're giving legal rights to someone, but the power of attorney, you can have in it different triggers for it to come into existence, and in terms of when the power is provided. But you want to have that sooner rather than later, because you can't give a power of attorney if you don't have capacity. And sometimes people wait too long to execute all these documents, and guess what? Now you're not able to execute a power of authority. Now someone, a next of kin, someone is going to have to go to the courts to get a guardianship. And that's costly, time-consuming, and may not be met and received well by the person, because, look at their situation and condition at the time. They may not understand what's going on. So a power of attorney, and it should be executed any age, because you never know what's going to happen. It's not just for the elderly. It's not. It also, though, it does assist. I see a lot of younger individuals entertaining a power of attorney to assist now with online banking and whatnot, to help out. And it does have an important function sometimes to keep people in their homes, keep their bills under control, avoid what is, predatory practices against the elderly, where someone else is taking care of the financial affairs. But the individual has to be agreed to cede the control, and that's sometimes a difficult factor to overcome.